Welcome back to CryptoLawTV. I'm the founder and your host, John Deaton. Today's topic is the Hinman deposition. It is very frustrating to read that deposition because of the redactions, the missing pages. The deposition's actually 418 pages, and all we received in the public is about 91 pages, but many of those pages are redacted. And that's my first observation. Why? Why does the SEC redact so much information and shield it from the public? Now, they can't claim that it's because of privilege. They can't claim that it's because of the deliberative process, because Jorge Tenrero, the lead attorney for the SEC, instructed Bill Hinman not to answer any of those questions. So why redact? If there is no privileged information that's contained in the deposition, there should be no need to redact. The public has a right to this information. Let's talk about Mr. Hinman's bias. Okay, let's go to page 38 at the very top, line 5. He starts getting asked questions about who Bill Hinman's clients were or his firm's clients. And he's asked about consensus, and his answer is no. And then he's asked on line 7, and how about the Ethereum Foundation? And the answer is no. But you got to understand here, a client is a very specific classification. So the Ripple attorneys, being smart, said, all right, let me back up a minute and let's broaden the question, right? And he goes on to state that he's going to define the Ethereum Foundation by their own words. And you can see there, the Ethereum Foundation is not a company or even a traditional nonprofit. Their role is not to control or lead Ethereum, nor are they the only organization that funds critical development of Ethereum-related technologies. And he goes on to explain that. And then he asks, do you believe you represented any company, individual, or entity that was involved in the Ethereum Foundation as I just described it? Let's get to the answer on page... Wait a minute, there is no answer. The answer is redacted because that was page 38. And then we get to page 41 is the next page, and look at it. Okay, redacted. Why? Let me explain to you how offensive this redaction is. Who someone's client is not privileged, all right? What's privileged is communications between an attorney and a client. All right. You can ask someone, do you represent? In fact, I just did a little Googling, right? And found out that you could find out who the clients are of Simpson Thacher. Sometimes they brag. They were involved in the IPO of Facebook. They were involved in the IPO of Google, Alibaba. They brag that their clients are Boeing, Microsoft, La Quinta. Okay, they were involved in the merger of the London Stock Exchange. Why is this being redacted and not shared with the public? Okay, there is no privilege, there's no deliberative process. Just who are your clients? Now, I know the SEC says, oh, well, that will deter people in the future from coming and being a public servant. So you're telling me if you just simply disclose who that person represents or who they've represented in the past, that's going to deter someone from serving in the role that Mr. Hinman served? Come on, man, give me a break. The next thing I want to show you is on page 42. Down at the bottom of line 19, I'd like to now direct your attention to the period after you announced your retirement from Simpson Thacher until you joined the SEC as a director of the Division of Corporate Finance. Okay, that's page 42 at the bottom. We go, and what's the next page that they give us? The next page is 50. 8 pages completely deleted, redacted, or whatever. All they're asking is, from this moment in time you retired, and we want to ask you questions related to from that period, that moment in time until you became director of corporate finance. Who'd you talk to? Did you work for anyone? Is there any type of meetings you had with people? Did you meet Joe Lubin, who is a co-founder of Ethereum and the founder of Consensus? Did you meet with Vitalik? Did you meet with anybody in the industry? How is that not relevant for us to know as the public? Yet it's being shielded from us. Now, I mentioned Joe Lubin and this meeting with Consensus. Consensus comes up later in the deposition. Guess what law firm represented Consensus? Jay Clayton's law firm represented Consensus. Okay, so I believe that Ripple has some type of information about from the moment that Mr. Hinman announced his retirement until he got to the SEC. Something's going on there. They have some information. They asked him about it, yet we, the public, don't get to find out. Not yet. Now, I want to show you an example of Mr. Hinman being an advocate, not a witness, but an advocate for the SEC. And we could do that by going to page 95. Let's go to line 9. Do you recall other issues that were brought to you and members of your staff about the application of the federal securities laws to digital asset transactions in which they sought guidance without seeking a no action letter? You see that? And the answer is yes. And he's asked, tell me what you recall on that issue. And what does Mr. Hinman do? All right, he wasn't asked about XRP. He wasn't asked about Ripple. He was just asked a general question about people. But his answer is very specific because he says, frankly, the one I recall, as though he only recalls one meeting, the most clearly is probably the one when XRP came in with a person who had my position before me. I didn't know XRP was an entity, but he says when XRP came in, as well as Enforcement Council, they were interested in there being a way to restructure what we were doing to bring it within compliance of the securities laws. And the first thing I said to them was, you're continuing to offer XRP without any kind of restrictions that would apply as a securities offering. If you want to come into compliance, you have to stop doing that. And they understood that, right? That is so gratuitous. He's saying that this is what I said to them, and they understood to it as though he can go in their mind and testify as to what they knew. Now, that's very important. Question on page 96. All right, other than the issues with respect to Ripple, can you identify any other lawyers that came to you, not seeking a no action letter, but seeking guidance with respect to transactions in digital assets? And the answer is yes. But look at what happens next. We have, again, redactions related to a question and answer, right? Why? There's no potential reason why. You want to know why it's not privileged? You want to know why it's not deliberative process? Because the question isn't asking about communications within the SEC. Judge Netburn stated that any communications with third parties that the SEC had to the outside world is fair game related to XRP, Bitcoin, or Ethereum, yet it is redacted. We go on, and then we get to page 97, and the question is, on line 4, any other lawyers you recall coming to you or members of the staff seeking advice on digital asset, the application of the federal securities laws to digital asset transactions other than what you've testified, okay? And then he goes on and he says, well, it was a big topic at the SEC. There's lots of folks coming in and asking for advice. And he goes on. And then when we continue to page 98, he then at the top, he gratuitously throws in something. Now he's already testified about Ripple. Question was, well, other than Ripple, and what's his answer? We had those kinds of discussions with XRP specifically. I didn't know that Mr. Hinman could actually talk to and have a conversation with a digital asset, but apparently he did. It says, we had those kinds of discussions with XRP specifically. If they were going to register, what would things be that would be relevant? Now you see immediately the Ripple lawyer moves to strike about XRP because I asked you for your recollection of meetings that didn't involve XRP. And what's Mr. Hinman's answer? I'm sorry, I missed that. No, he didn't. No, he didn't. He knew that the question was, other than XRP, can you give us any other examples? And he starts talking, and then he finishes the answer with, and again, let me tell you about XRP, okay? That's him gratuitously putting on the record as much damaging information as he can to help the SEC. Let's go to line 9, page 160. Did you direct Ms. Starr to contact Mr. Lubin to set up a meeting with the Division of Corporate Finance? Okay, Ms. Starr is someone who worked at the SEC, and the question is, did you direct her to set up a meeting with Lubin? Remember, Joe Lubin is the co-founder of Ethereum and the founder of Consensus. And the answer is, I don't remember doing that. It's possible, but I don't have a specific recollection of asking her to do that. I'll leave it to you whether you think that's something that Mr. Hinman would remember. And of course, the answers redacted again. We go to page 163, and you can see that the Ripple attorneys on line 2 state, did you have an understanding in advance of this December 13th meeting with Consensus as to what specific issues involving blockchain tokens and securities regulations they wanted to address? His answer, no, I don't have a recollection of specific set of topics. Then it goes on at the bottom, line 20. So let's go to the meeting on December 13th, 2017. You attended a meeting on that date with representatives of Consensus, correct? And you have to know how to read through the lines or the redaction. If we go to page 308 on line 13, are you aware that Sullivan and Cromwell represented Consensus? Mr. Tenrero objects, and the answer is, I didn't know if they were a firm client. I think some of the people at the Consensus meetings had a Sullivan and Cromwell background. I wasn't aware of their relationship. Yeah, right. So the chairman of the SEC's former law firm, Sullivan and Cromwell, you didn't know that they represented Consensus, which is founded by Joe Lubin, who is the co-founder of Ethereum. You didn't know any of these connections, right? Now, if you go to page 259, is an example of bias that I told you I would show you. This is an answer of Ripple. Now, understand here, this question relates to the redacted questions about his speech, right? And if you see at the top of line 2, the question is, fair to say that the moderators believed that if you call 10 different law firms, they give you 10 different answers. Mr. Tenrero makes this long objection. And then Mr. Hinman goes on to say, I don't know what the moderators thought when they were coming up with these questions. What was in their mind? If they thought it was a colorful way to describe a question, to ask the question. I really don't know what they had in their mind. It's hard for me to read somebody else's mind. But wait a minute, Mr. Hinman, you earlier had testified that you knew that Ripple's attorneys understood that you believed XRP was a security. So you can read their minds, but you can't read the minds of these folks that were moderating your remarks. I want to turn to page 256, line 7, okay? Because this is what's important to XRP holders. Question, well, do you agree that one of the key points of your June 14th, 2018 speech was that, quote, the token and the offering may be distinct. The token may be offered in a securities offering at some point, and the future offerings may be non-securities. This is the part of the speech where Hinman says, hey, it may have started as a security, but it has sufficiently transformed into no longer being a security. Ripple is simply asking, Is that kind of one of the key distinctions of your speech? And Mr. Tenrero, of course, using code that I've already described, objects to form. Do you want to break that up? He's basically saying, you want to break that up? That's kind of a compound question. Now, he doesn't use the word compound, but that's in essence what he's getting at. Mr. Figo says no. Mr. Tenrero's not done, right? He's not done with the code. And the code is, it's impossible to answer them. Go ahead. At that point in time, Mr. Deaton would have said, well, it may be impossible for you, Mr. Tenrero, but you're not the one that's on the stand. You're not the one that's under oath. It is Mr. Hinman. And so Mr. Hinman is the one here to testify, not you. Now, after Mr. Tenrero talks about the impossibility of that, to answer that question, Mr. Figo says, do you disagree that that was a key point of your June 14th, 2018 speech? Answer, I think that it's too narrow a reading of the speech, right? In other words, he doesn't want to give a concession to Ripple. Mr. Tenrero has objected, said it's impossible to answer, i.e., man, this answer could hurt. And what does Mr. Hinman do? He hem and haws again. That's just, too narrow of a reading of the speech. It's an essence of the speech. He said, look at the speech. He said, if you set aside the fundraising of Ether, it is sufficiently decentralized and no longer becomes a security. It's arguably the central point of his speech, yet they won't give that concession. And that's important for XRP holders. It's unfortunately that we weren't in there and able to ask questions and ask follow-up questions of that, because that's our whole case. The token itself is not a security. It's a clear issue. The asset, the token, is not in and of itself a security. It may be sold as a security, it may be marketed as a security, but it is not in and of itself a security. That's the whole case for XRP holders. But unfortunately, we weren't there to present those questions in a more forceful way. I can tell you that we will continue to fight to get in this case, to get access to this information and get these answers before the public, because it is absurd, ridiculous that any lawyer of the SEC would stand up and say that the token itself is inherently a security.